Greetings, tort students. This review covers the doctrine of res ipsa loquitur. Res ipsa loquitur is a Latin phrase that means the thing speaks for itself. The simple idea at the core of the doctrine is that a defendant's negligence can sometimes be inferred from the very nature of the accident that caused the plaintiff's injury. In every negligence case, the plaintiff bears the burden of proving that the defendant failed to exercise reasonable care in the circumstances. This generally means that the plaintiff has to have some evidence that the defendant did something unreasonable in the circumstances. For example, if Lee and Shaw crash their cars in an intersection and Lee accuses Shaw of negligence, Lee might testify or even produce video evidence from his car's dash cam showing that Shaw failed to stop at a stop sign. But in many cases, the plaintiff will not have such evidence of any specific negligent act or omission by the defendant, such as Shaw's failure to stop. Suppose a fine gentleman, call him Mr. Byrne, is walking along the road when a barrel of flour rolls out of the defendant's upper floor store and lands right on Byrne's head. Byrne sues the store owner and tells the court his story, but admits he has no evidence of any specific act or omission by the defendant that would have caused the barrel to roll out of the defendant's store. Should Byrne's action be dismissed on the grounds that the plaintiff lacks evidence to carry his burden of proving breach of duty? These were precisely the facts and the issue in the classic English case of Byrne versus Bodle, decided in 1863. The lower court agreed with the defendant and dismissed the plaintiff's case. But the appellate court reversed, astutely observing that a barrel could not roll out of a warehouse without some negligence, and declaring that it would be preposterous to require the plaintiff to produce further proof of negligence. To be sure, it isn't impossible for a barrel to roll out of a store without negligence. For example, a big dog could have pushed it over, or an earthquake could have toppled it. The appellate court's point was not to deny this, but that further evidence in a case like this is not needed to conclude that negligence was the most likely explanation. Over the years, the doctrine of res ipsa loquitur, or res ipsa for short, has been applied to an expanding array of accident types involving all manner of falling objects, such as elevators and even airplanes. But it has also been applied to other types of accidents, such as trucks crashing into parked cars, foreign objects found in canned food, and even babies switched by hospitals at birth. What all such accidents have in common is that they bespeak negligence. They are so likely to have a negligent cause that the occurrence of negligence can be inferred from the mere fact that the accident happened. In such cases, as long as this unknown negligence can fairly be attributed to the defendant, the jury will be permitted to infer that the defendant breached a duty of care even when the plaintiff has no evidence of exactly what that breach was. Modern-day courts tend to require a plaintiff to establish two foundational conditions or elements in order to invoke res ipsa loquitur. First, the event that caused the plaintiff's injury must be of a kind that ordinarily doesn't occur in the absence of negligence. Second, other responsible causes must be sufficiently eliminated by evidence. In other words, the negligence that likely caused the accident must fairly be attributable to the defendant. So, these are the two basic elements that a plaintiff must prove in order to be able to assert res ipsa loquitur. If either is missing from the plaintiff's case, then the doctrine cannot be invoked. Let's try out this framework on some hypothetical cases. Isaac happens to be walking in front of a tall hotel when a coffee mug falls from above and hits him on the head. Isaac suffers a concussion and sues the hotel, asserting negligence. He has no evidence to show what caused the mug to fall, but several witnesses say they saw it drop from one of the hotel's upper floor balconies. If Isaac has no evidence of any specific negligent act or omission that caused the mug to fall on his head, can he rely on the doctrine of res ipsa loquitur to establish the hotel's negligence? The answer is no. We may feel badly for Isaac, especially because he may have no way of proving the circumstances that caused the mug to fall, but the mere fact that he cannot obtain evidence is not enough to permit him to invoke res ipsa. He has to prove the two foundational elements. Here it is the second element, which goes to attribution, that fails. It may be true that coffee mugs don't fall from hotel balconies unless someone was negligent, or worse. But this situation is unlike the falling barrel case, where it was clear that the barrel was something that had been in the defendant's control. In Isaac's case, there's no similar foundation for attributing the likely negligent handling of the mug to the hotel as opposed to, say, a guest of the hotel. How about this very different type of case? Gilbert undergoes a surgical procedure on his shoulder conducted by Dr. Harris. After the operation, Gilbert experiences abnormal pain at the surgical site, and it is later discovered that a small piece of a surgical sponge was left inside of Gilbert's body. Gilbert sues Dr. Harris and asserts res ipsa loquitur to establish that Dr. Harris breached a duty of care. Can Gilbert rely on the doctrine of res ipsa loquitur to establish Dr. Harris's negligence? The answer is probably yes, though there may be some room for argument as to the second foundational condition. Gilbert has a good argument that both of the foundational conditions of res ipsa loquitur are satisfied here. First, objects used during a surgical procedure normally don't get left inside the patient's body unless someone wasn't being as attentive as they should have been as they were stitching up the patient. Second, Gilbert could argue that the negligence that likely occurred can probably be attributed to Dr. Harris, the surgeon, since he was in charge of the operation. However, it is possible that the second foundational condition might be disputed. For example, Dr. Harris might argue that it was the responsibility of another member of the surgical team to make sure that no materials were left in the patient's body at the end of the operation. This dispute does not mean that res ipsa loquitur cannot be applied. What it does mean is that the trier of fact would need to decide this foundational issue before it could use res ipsa to find Dr. Harris negligent. The plaintiff and defendant might need to introduce expert testimony to support their position on this matter, since the question of who has responsibility for clearing the patient's body of external objects at the end of an operation might be determined by a medical standard of care. Similarly, in technical cases, expert testimony can be used to establish that an accident would not ordinarily happen without negligence if this would not be obvious to the layperson. In general, keep in mind that the presence of a dispute about whether one of the elements of res ipsa is satisfied does not mean that res ipsa fails. Such disputes are considered questions of fact for the jury to decide. If the jury finds that the elements are satisfied, then it can apply res ipsa to infer the defendant's negligence. Finally, what can a defendant do when a plaintiff is successful in establishing both foundational elements of res ipsa? Consider the following question. True or false? Where res ipsa loquitur applies, negligence is thereby established and judgment must be entered for the plaintiff. This is false. Most courts regard res ipsa as a rule that allows the jury to find negligence, not a rule that requires a finding of negligence. Once the foundational elements of res ipsa are established, the defendant always has both the incentive and opportunity to bring evidence that would absolve it of negligence. For this reason, it is sometimes said that res ipsa can serve to smoke out evidence that would otherwise never see the light of day. Let's return to Byrne versus Bodle, the falling barrel case. What kind of evidence could someone in the store owner's position present if res ipsa applies? The most obvious strategy would be to show that, despite what might be said of ordinary cases of runaway barrels, there was no negligence in this one. Perhaps the store owner could testify about all the steps that were taken to secure his flour barrels, how he always stored them upright and away from walkways, the safety precautions that were taken by his workers in transporting them, and so on. Or maybe he might submit evidence that despite all reasonable precautions, a worker transporting the particular barrel destined for burn had an unforeseeable heart attack that caused him to drop it. These are just imagined defenses, not ones available in the real case. The point is that while res ipsa loquitur allows a jury to find negligence based on minimal evidence, the defendant in a res ipsa case is always entitled to produce evidence to show that the accident actually happened due to non-negligent causes.